Dr. Lonnie Shavelson is photographed at his home in Berkeley, California, on Wednesday, May 30, 2018. Shavelson is a palliative care doctor who assists patients who are using the state's End-of-Life Option Act, which is now on hold after the Riverside Superior Court struck it down. Jane Tyska, Bay Area News Group. The terminally ill patients who call Berkeley physician Dr. Lonnie Shavelson are reconciled to waiting for death. But now they must wait for something else, too, the slow wheels of justice, delivering a court decision that determines whether or not they'll have access to life-ending medication. A Riverside Superior Court judge on Wednesday morning rebuffed an effort to restore California's End-of-Life Options Act, which gives dying patients the right to end life on their own terms. So the state must try again. The next motion, urging the judge to cancel a ruling last week invalidating the law, is set for June 29, a month from now. Meanwhile, major hospital systems such as Stanford, Kaiser Permanente, UC San Francisco, John Muir and California Pacific Medical Center are suspending access to the medication, which has been legal for the past 7 months. For families affected, this brings up so much trauma, said Vijay Periakoil, director of Stanford's Palliative Care Education and Training Program and the Stanford Hospice and Palliative Medicine Fellowship Program. They thought it was legal, and now they're back again in a period of uncertainty. While doctors will continue to offer the best possible support, at this point, Stanford doctors are not going to be writing any new prescriptions, while we all wait for the final judgment on this act, she said. At UCSF, we are going to suspend prescriptions of the drug, said Susan Penny, Executive Director of Risk Management for UCSF Health. We will continue to support all of our patients at the end of life and with end-of-life counseling. Physicians who participate in the act will continue with the process, with the exception of prescription of the drug, until this matter is resolved legally. At Sutter Health, which owns the large network of hospitals including Eden Medical Center, Santa Rosa Regional Hospital and Novato Community Hospital, doctors have been alerted that activities authorized by the act may not take place, without further guidance from the courts, said Emma Dugas of Sutter Health. Hospices are also suspending their programs. For the time being, I do not believe we can participate in any additional End-of-Life Option Act activities until the court addresses this latest decision, according to Dwight Wilson, Executive Director of the San Mateo-based Mission Hospice. Dr. Shavelson's practice, Bay Area End-of-Life Options, extends from Yuba City and Gualala to Santa Cruz, anywhere within a 3-hour drive of the Bay Area. He consults not only with physicians in hospitals, but also with patients themselves, offering care to patients who choose him as their attending physician, when they can't find a local doctor to help. When a dying cancer patient from San Jose called Shavelson on Wednesday to seek end-of-life medication, the Berkeley physician helped with everything that is legally possible: engage in deep conversation, make a care plan, review medical records, schedule home visits and start a 15-day waiting period. But the most important step, prescribing the drug to ease suffering and death, is out of reach. He is advising patients who already have prescriptions that the decision is theirs whether to take the medication or not. Dr. Lonnie Shavelson is photographed at his home in Berkeley, California, on Wednesday, May 30, 2018. To the right is his medical bag, which he used to make house calls. Shavelson is a palliative care doctor who assists patients who are using the state's End-of-Life Option Act, which is now on hold after the Riverside Superior Court struck it down. Jane Tyska, Bay Area News Group. We are not sure if the cessation of the act applies retroactively, and allows those patients to take their medications, since those patients fulfilled all aspects of the act before the law went down, he said. or the law invalidates their ability to now take the medication, and they run the risk of having their deaths declared suicides, and all who help them can be accomplices to suicide. He is refusing to classify any death from medication as a suicide. We are continuing to take in new patients, take their first and second verbal requests, start the 15-day waiting period, etc., he said. We are advising those patients that we have no idea if these dates and events will be honored if the law comes back up, or if they will have to repeat these requests and go through a second 15-day waiting period. We also tell them the law may remain invalid until they die, he said. But it is our advice that there is no harm in hoping, so we are taking these requests and starting the clock ticking on the waiting period anyway. Polls show that California voters overwhelmingly support the state law, called the End of Life Options Act, with 65% favoring the law compared with 28% who are opposed. Support cut across all political party and ethnic lines, and varied little among genders and age groups, among the voters polled, but it is vulnerable because of the way it was passed in 2015, in a special legislative session to fix healthcare funding for the poor, and then signed into law by Gov. Jerry Brown. The gambit allowed the bill's supporters to bypass opponents, but has landed them in court. Riverside Judge Daniel A. Otolia judge has twice ruled in favor of opponents who say the state constitution requires legislators to stick to the topic agenda of a special session. We are deeply disappointed that the court ruled against us, but we thank Attorney General Becerra for defending the law, said Kevin Diaz, National Director of Legal Advocacy for Compassion. But the one-month delay until the hearing is unacceptable, he said, because in the meantime the law is not in effect and terminally ill Californians now are left without the option of medical aid and dying to peacefully end unbearable suffering. All you're doing is taking a piece of my healthcare out of my plan, says Burbank resident Matt Fairchild, 48, on Friday, May 18, 2018, of the effects of a Riverside judge's suspension of California's right to die law. Fairchild has been suffering from metastatic melanoma that since 2013 has been in his lungs, bones and brain. Photo by Sarah Ryan-Gewertz, Pasadena Star News, SCNG. In his petition to the court, plaintiff Matthew Fairchild, a 48-year-old, retired Army Staff Sergeant in Burbank with terminal melanoma, said, "I am devastated to learn that this court has made a ruling that will interfere with my ability to receive a prescription from my doctor for aid in dying medication. This ruling will likely mean that I have no option when my suffering becomes intolerable, and that's now all suspended. This isn't like renting a car, and now you can't. This isn't like being denied a home mortgage," Shavelson said. "It is being denied the way you chose to die. When death is pending, uncertainty is a large wrench to throw in the middle of all that," he said. Sponsored content. What's view-through, and why should you track it? By if your digital ad campaign generates the same click-through rates as the average campaign, then more than 99% of people who see your ad. You might also like you can self-heal your aches and pains with this Ace Pro Academy, an exclusive peek into Singapore's country club scene, intercontinental hotels, and inspire at Tech Saturday. Little day out, 1 o'clock when driving is a choice. Choose your partner wisely. Audi for some. Express lane rules are baffling. Roadshow. MercuryNews.com. San Jose motorcyclist killed in crash on rural road. MercuryNews.com. Trump's alleged failure to use condoms with Stormy. MercuryNews.com. Recommended by